All right, if you're a manager, believe it or not, you're making legal decisions pretty much every single day. I mean, from that very first interview to cutting the last paycheck, every step you take has some kind of legal weight. So, what we're going to do here is give you the playbook, a guide to help you navigate that whole legal landscape and, lead your team with real confidence. Okay, so here's what we've got lined up. We're going to walk through the entire employee journey, right? We'll start with the legal tightrope of hiring. Then we'll get into on-the-job safety. After that, we'll talk about the art of the exit, what's up with severance agreements, and then tackle the really tricky stuff, like layoffs. So yeah, let's just dive right in at the beginning. All right, first up, hiring. And let me tell you, this is basically a legal minefield. It's so easy to make a mistake. Even a question that sounds totally innocent can blow up into a discrimination claim faster than you think. Our whole goal here is to help you spot those traps and sidestep them from day one. So this is the big one, isn't it? What can you actually ask in an interview? I swear, every manager worries about this. That line between just trying to get to know someone and, oops, breaking the law, it can feel incredibly thin. Okay, here's the golden rule. You gotta remember this. Focus on ability, not disability. So you can totally ask, and you should ask, how would you perform the essential functions of this job? That's fair game. What you absolutely cannot do is ask something like, do you have a disability that would interfere with your ability to do the job? See the difference? It's subtle, but legally it's a huge deal. Okay, so what if you're using background checks? Well, you've got to follow the Fair Credit Reporting Act, no exceptions. It's a really strict three-step dance. Step 1, you must get their written consent first. Step 2, let's say the report comes back with some red flags. Before you do anything, you have to give them a copy and a chance to see it. And finally, step 3, if you decide not to hire them because of what's in that report, you have to send them a final letter, an adverse action notice. You got to follow all 3 steps. Wow. This case right here is a perfect and kind of scary warning about making promises. So, get this. Microsoft offers a guy a job. He's so sure it's a done deal that he quits his old job and even buys a new house. Then, Microsoft pulls the offer. Now, you'd think at-will employment would cover them, right? Wrong. The court basically said, nope, you made promises and he acted on them, so you could be on the hook for his damages. The lesson here is so simple. Don't make promises you can't 100% keep. Okay, so the person's hired, they're on your team. Now your legal duties kind of shift gears. Your main focus turns to providing a safe workplace. And look, this isn't just about being a nice person or a good manager. It is a straight-up legal requirement. The big law you need to know here is the OSHA Act. It's really the cornerstone of all workplace safety. It's a federal law, and its mandate is super clear. Your workplace has to be free of recognized hazards. Known dangers that could seriously hurt or even kill someone. And that covers everything you can think of, from weird chemicals to a rickety ladder. So what does that actually mean for you on a regular Tuesday? It's pretty simple, really. You always have to take employee safety complaints seriously, always. Make sure you have your workers' comp coverage. And here's a big one. Don't ignore anything OSHA tells you to do. And absolutely don't fire or punish an employee for reporting a hazard. That's called retaliation, and it's illegal. They have a right to speak up. And if you think your responsibility ends when your employee walks out the office door, well, think again. Check out this story. An employee for International Paper was on a work call while driving and caused a massive car accident. The result for the company? A $5.2 million settlement. The takeaway here is huge. Your company's liability can literally follow an employee wherever their job takes them. Okay, let's face it. Sooner or later, every employee is going to leave. It's just part of the cycle. But how you manage that exit, whether they quit or you have to let them go, demands just as much legal care and attention as the day you brought them on board. All right, here is a classic scenario that makes pretty much every manager nervous. A former employee puts you down as a reference. And maybe it's someone you had to fire. The phone rings. What can you legally say without landing yourself in hot water? The big legal risk you're trying to avoid here is called defamation. That's just a fancy word for making a false statement that hurts someone's reputation. So what's your best defense? It's simple. The truth. Your absolute best protection is just to stick to the facts, things you can actually prove. So here are a few simple rules of the road for giving references. 1. Keep it brief. 2. Stick to the facts. 3. Don't be spiteful. Leave your personal feelings out of it. And this next one is super important. Don't give a glowing review to a problematic or even dangerous employee just to pass them on to someone else. That can come back to bite you. You know, honestly, the safest play is to have one person in the company, maybe an HR, who handles all reference requests, period. All right, now let's talk about a couple of tools that can really help create a clean break when an employee leaves. We're talking about severance and releases. The whole point of these is to protect your company from legal trouble down the road. So, what exactly is a release? Well, it's pretty straightforward, really. Think of it like a contract, a deal. The employee agrees not to sue the company for anything, and in exchange for that promise, the company gives them something valuable, which is usually a severance package. But for that release to actually hold up in court, there are a few things that are absolutely non-negotiable. First, you have to give the employee something of value they weren't already entitled to. Second, the agreement has to be super clear about what rights they're waiving. Third, they have to be given enough time to think about it. You can't rush them. And a really important one, there are special rules and extra protections for workers who are 40 or older. You gotta know those. Okay, and finally, let's get into layoffs. Handling one person's departure is one thing, but a big, large-scale layoff, that is a whole different ballgame. It comes with its own very strict set of federal rules you have to follow. If your company is even thinking about a large layoff, the very first question you have to ask is, does the federal WARN Act apply to us? This is a law that requires you to give workers advance notice, and it all comes down to a few key numbers. Okay, first number. The WARN Act generally only kicks in for companies that have 100 or more full-time employees. So if you're smaller than that, you're probably off the hook for the specific federal law. But be careful because some states have their own mini WARN Acts. All right, next number. The law gets triggered when you have a big event, like a mass layoff. For example, if 50 or more employees at a single site lose their jobs within a 30-day period, ding, 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 that can trigger the WARN Act. And if the WARN Act does apply to your situation, this is the magic number you have to remember: 60 days. You are required to provide at least 60 days written notice before the layoff happens. And if you don't, you're looking at some serious financial penalties, like having to provide back pay and benefits for every single one of those workers. And to wrap this section up, please don't forget that these laws can be wildly different from state to state. Just take a look at the rules for a final paycheck. In Massachusetts, you have to pay them on their last day. In Utah, it's within 24 hours. But then you've got Michigan and Virginia, where it's just the next regular payday. The point is, you absolutely have to know your local rules. So we'll leave you with this one last question to think about. How much are you really leaning on your company's at-will employment policy? A lot of managers think it's this magic shield that protects them from anything. But as we've just seen, it can be totally undermined by one broken promise or a simple claim of discrimination. At-will is not a suit of armor. Your best and really your only defense is to know the law and make sure you're applying it fairly every single day.